Hello, very good morning to you. You are welcome to The Big Issue. My name is Selom Adunu. The show is live and interactive, and you can join us via our WhatsApp line 020-444-7033 or 0549-986-996. We are on 97.3 City FM and, of course, on ChannelOne television. We are also on our socials, and we'll be happy to have you with us throughout the program. There are two key issues we are looking at this morning. First has to do with a religious and legal matter. The Wesley Girls High School is being involved in a matter with a lawyer who is a Muslim, and it's become a Muslim rights matter against the school. Should I call it a constitutional right matter versus Wesley Girls? The matter is that the lawyer is gone to court asking the court to declare as unconstitutional some practices of Wesley Girls Senior High School. That is, according to the plaintiff, or the allegation is that in Wesley Girls, Muslim students are not accorded the full freedom to practice their religion, in the sense that they are prevented from fasting and they do not have the freedom to even pray. Whether that is true or not is a matter the court will come to, but these are the allegations the plaintiff is put before the High Court and the Supreme Court, and the Supreme Court is to interpret and make a determination. We want to look at this, of course. We know it's in court, but there are various facets of this. This is Wesley Girls, but we're having a general discussion on the subject. How should this matter be looked at? We've lived in harmony over the past several years without any indication of unhappiness from any quarters. And the question is, how should it be? A missionary or missions put up schools to train people along a certain line, morally, religiously, ethically. And so does it mean that once an external person or anybody who enters the school tacitly agrees to those rules and regulations of the school? The other dimension is that the school receives public funding. And so where does that leave the school as one run by missions, the state? It's a very delicate discussion we're having this morning, and we hope to make some headway with that. Also, later on in the program, we'll go to Parliament. We'll be in Parliament. The Minority Leader has been referred to the Privileges Committee, or the Committee of Privileges, by the Speaker of Parliament. What does this mean for Afenyo-Markin? The Speaker of Parliament, who made a referral, provided some terms of reference, including ascertaining the facts of the matter. The matter is that Afenyo-Markin, who was on the ECOWAS Parliament, or Ghana's delegation to the ECOWAS Parliament, this time round was removed as a member of the delegation. The thinking or the explanation was that that role was reserved for deputy leaders, and that Afenyo-Markin is no more a deputy leader, he's a minority leader, and so he doesn't have to be there. And that the ECOWAS Parliament is quite strict on female representation. And so Patricia PJ, who is the deputy leader of the minority, was replaced or was substituted for him. Of course, she has declined it. And so when they went to the Parliament, Afenyo-Markin, or they went to meet Afenyo-Markin there, he went there on his own, and we understand it was an embarrassing situation. Ghana's delegation was nearly not sworn in. When they came back to Parliament, Majority Leader, who is the leader of the House, thought the action or conduct of the Minority Leader was embarrassing and contemptuous of Parliament, and so asked for him to be referred to the Committee of Parliament for appropriate sanctions to be meted out to him. Speaker says prima facie case in respect of contempt is being brought up against him, or is being established against him, and so the referral was made. We are yet to see how that goes. But three options, or three things that may happen. He may just be reprimanded, he may be suspended, or he may be expelled from Parliament. We don't know which one will happen, but the nature of this Parliament is interesting. The NDC, which holds the majority, indeed, an absolute majority, two-thirds majority, dominates every committee, and work at the Committee of Privileges is based on that same representation. And in the end, it may come down to votes. We don't know how it will be. But of course, yesterday, at the funeral of the late former First Lady. We saw Afenyo-Markin and Mahama Yariga happily conversing and chatting and nodding their heads. What does that mean as well? We'll get to that. Also, Banda sits on tenterhooks. A court is asked for a rerun of that election. This member of parliament, is he still an MP or he loses his seat? Speaker says not yet. There should be 7 days after a decision from the court. And so we are waiting for that. What does that happen? Of course, we understand it's appealed and it's also filed a stay of execution. Will Speaker go ahead after 1st of December to declare the seat vacant? And will the Electoral Commission organize a rerun? What happens if a rerun is conducted, somebody else wins, and then Mr. Nyindam wins the rerun, or no, I mean wins the court case? Where would that put us? So it's an interesting discussion, so we'll look at all of that. So this is our show for this morning. I'll take a short break. When I return, I will provide you some updates, introduce my guests, and then we'll hit the ground running. Don't go away. You're welcome back. This is The Big Issue. We are live on 97.3 City FM and on ChannelOne television. We're on YouTube as well. Two key issues we're looking at this morning: Osman versus Wesley Girls. The matter where a young lawyer, a Muslim, is taking on the Ghana Education Service and the Wesley Girls Senior High School for some practices he deems unconstitutional. He alleges that the school does not allow the full expression of the Islamic faith of some of its students. They say that during the period of Ramadan, which is a key period in Islam, the students are not allowed to fast and that they are not even allowed to pray. The court this week instructed or ordered Wesley Girls to file a defense or to respond to the allegations of the plaintiff. The Attorney General kind of supports the school, but the Education Minister says nobody's rights will be trampled upon. So it appears as an interesting legal matter. But of course, the matter is in court. We are discussing it generally. We've lived together for centuries as Muslims and Christians. And where are we going with this? What should the conclusion, or what would the conclusion mean for Ghana's educational system? And 8 out of 10, when you look at the top schools in Ghana, those will be missionary schools or mission schools. What does that mean for people of other faiths? Can they attend those schools and still practice their faith? Does the fact that you go to those schools mean that your faith must be on hold whilst you are in the school? I mean, what can the state do? A lot of these schools have public funding. What does that mean as well for those schools? These are the matters we'll be dealing with. Also, Parliament. We'll go to Parliament. Minority Leader has been referred to the Privileges Committee. He likely faces a reprimand, suspension, or expulsion. Of course, they may not even do anything to him at all because he went to a place he didn't have to go. He's no more a member of the ECOWAS Parliament, or at least from what Parliament says and endorsed by the Speaker. He was to be replaced by his deputy. But when the delegation went to the Parliament, Afenyo-Markin Osahini found himself there, and he insisted to be sworn in as a member of the Parliament. Indeed, he is the third Speaker of that Parliament, Deputy Speaker of that Parliament we hear. But what does that mean? Does it mean that your nation or your country cannot take you out, or it must be voluntary? It must be voluntary resignation from that house. We will want to understand all of this today. And what implication does that hold for Ghana's Parliament should the minority leader be expelled on these grounds? Also, the people of Banda are on tenterhooks. The courts want that election rerun. This member of Parliament in that area, or for that area, Martin Nyindam, is appealed the decision, filed a stay of execution, we understand. And so, Speaker says we have to wait for some time before declaring that seat vacant. We'll see what the implications of that declaration or otherwise will be, given all the angles we will discuss today. Now, let me provide you some update. Now, the Supreme Court has directed or ordered Wesley Girls Senior High School to formally respond to allegations that it bars Muslim students from practicing their faith. The directive follows claims filed by private legal practitioner Shafiq Osman, which the court says forms the core of the constitutional challenge before it. The school has 14 days to file its response.
Plaintiff Shafiq Osman alleges that Wesley Girls Senior High School enforces policies that bar Muslim students from observing their religious practices, including fasting and prayer, and compels them to participate in Methodist worship because the school is owned by the Methodist Church. He argues that these actions amount to systemic discrimination and violations of religious rights. During Tuesday's sitting, the Attorney General applied to withdraw and replace an earlier statement of case, although the panel, chaired by Justice Gabriel Scott Foreman, granted the request. The bench raised concerns that the amended document still failed to address the core factual allegations. The court therefore ordered the first defendant, the Board of Governors of Wesley Girls High School, to respond directly to the specific claims. The panel noted that the allegation that the school prevents Muslim students from practicing their faith is particularly serious and requires clarity. Meanwhile, the Supreme Court has also granted permission to Democracy Hub to file legal submissions as amicus curiae, but only after all parties have filed their respective documents.
Yeah, so the Ministry of Education has meanwhile cautioned that it will not tolerate any infringement on students' rights to freely practice their religion. Addressing Parliament, Education Minister Haruna Idrisu said renewed concerns over alleged discrimination at Wesley Girls underscored the need for schools to uphold the rights of every Ghanaian child, regardless of religious background.
That there is some ongoing debate on restrictions on Muslim students in Wesley Girls, which conflicts with international human rights standards and even standard expected of us in Ghana's Constitution and Article 33(5) and 26(1) of the Constitution. And then to assure our colleagues that we have a duty to uphold the rights of every Ghanaian child and to uphold the rights of every Ghanaian citizen. No right is divisible, and that we will not countenance any action by any person to deny any Ghanaian girl the opportunity to profess or practice any religion.
The debate continues to intensify as the Ghana Catholic Bishops' Conference and the Christian Council of Ghana have defended the right of mission schools to preserve their religious identity. In a joint statement issued on Tuesday, November 25, the two bodies addressed growing public concern over whether non-Christian students, particularly Muslims, should be allowed to fully observe religious practices in such schools. They stressed that their position rests on protecting the legacy of institutions they have operated for more than a century. Separately, the Methodist Church of Ghana has dismissed suggestions of religious discrimination at Wesley Girls Senior High School. Mind you, the Wesley Girls Senior High School is a Methodist school. The Methodist Church insists the school's traditions are lawful, inclusive, and essential for maintaining discipline. In a statement dated Friday, November 28, the church acknowledged reports of a Supreme Court suit, that is Shafiq Osman versus the Board of Governors, Attorney General, and Uganda Education Service, but said it is yet to receive official notification. It added that steps are being taken to obtain court documents for its legal team. The church maintained that portraying the school as a public institution engaged in discriminatory practices is inaccurate. Founded in 1936 by Harriet Wrigley, Wesley Girls says its mission has always been to develop the intellect, character, and skills of the girl child without discrimination. So this is the matter we have before us. My guest this morning, Isaac Boama Nyakun, the Honorable Member of Parliament from the Fia constituency in the Western region. Professor Epieje Itua, who is, of course, Professor of Law at the University of Ghana School of Law. We have Apostle Emmanuel Oakley, who is a Ghana Pentecostal and Charismatic Churches Council General Secretary. And, of course, Andrew Apia Dankwa, Head of Legal of the United Party. We'll have Hamza Suwini, who is Legal Counsel for Shafiq Osman, and a member of the NDC Communications team, join us later in the show. Of course, we'll have a few other persons from the Ghana Education Service weighing in later in the show. But for now, good morning, gentlemen. Welcome to the program.
Good morning. Good morning.
Yes, let me start off with Professor Kojua PJ Tua. He has been teaching law for a long time. He's a human rights legal luminary. It's safe to call him that way. And see what he thinks about this whole thing. Hello, good morning, Prof. Welcome to the program. This is quite an interesting case. It's been talked about in many places, but this time around, somebody is taking a bold step to test the laws in respect of this. What's your initial impression about the happenings of the last few days in respect of this case? And of course, what you might know from your own experience as happens or pertains in mission schools.
Good morning, Salom, and thanks for having me. Yeah, the case raises very interesting issues that I think we need to look at it objectively and from a dispassionate perspective so that we will not let sentiments overrule or influence the outcome that we have. So we have on one hand the Wesley Girls School arguing that the school founded on the Methodist principles and founded by the Methodist Church has certain obligations to uphold certain principles or tenets which are in line with the Methodist faith. And therefore, the argument by Mr. Shafiq that it is being practicing religious discrimination is wrong. It's not true. But looking at it from my angle, we need to first of all understand whether this is a public school or a private school. If it is a private school, the law allows for a private institution to have some leeway in determining its or influencing how the school is run on religious grounds. So in the first place, the institution, everybody has a right to set up a school. And if you set up a school, there's a limit to which you can allow for certain practices and the way that the school should be run without violating the Constitution. However, if it is a public institution, the rules differ. Because as a public institution, it is open to all citizens of the country to attend, and therefore discrimination of any form cannot be allowed to determine who qualifies to enter the school and who qualifies to practice in what state or manner. From the discussions going on, I see that the Methodist Church is contending that the school remains a church or religious-based institution. But from my understanding of a public assisted school, so long as the government is involved in paying the fees of the teachers and subjecting the school under Ministry of Education and then the Ghana Education Service rules, then that institution becomes a public institution. And therefore, freedom of religion, which is enshrined in our Constitution, should be respected. Otherwise, it will lead to other violations of the Constitution, such as the one on freedom against discrimination, and then equality before the law. And then also even in the context of freedom of expression. So in that regard, my initial take on the matter is that it doesn't lie in the bosom of the school authorities or its board to conclude that Muslim children should not be allowed to practice their faith. I think that it cannot be a full-scale enjoyment of everybody's freedoms because there are competing interests here. When you talk about freedom of religion, it is about the freedom that somebody has to profess his or her religion. And so one cannot use a public institution to limit somebody's right to enjoy the freedom. But the competing interests should end in a way that we're able to find a common ground between the school and the students so that it will create a balance such that the students can profess their religion at the same time recognize that a right is not absolute. In this case, the right to freedom of expression is not absolute. So it's subject to certain limitations. So when we bring in the limitations, it can determine how those rights can be enjoyed, while at the same time, the institution that is a Methodist-based institution can also enjoy certain freedoms that pertain to that particular belief or doctrine that the Methodist Church has. So that at the end of the day, there'll be peace and there'll be orderliness on the campus. Students can learn to develop their full potential, and then also to practice their faith in such a way as to even support their learning environment. So thank you. That will be my initial thoughts on the matter.
Yes. So, so the Wesley Girls Senior High School, that's a public institution because it receives public funding. But do we have a middle ground? Of course, the Ghana Education Service will have to answer this, whether we could have some arrangement for such schools, because the missions made huge investments in building those schools and continue to influence those schools. Of course, government pays the salaries of teachers, and government now builds infrastructure, and government is taking over those schools. But what advantages will these missions get then? Why did they establish the schools? They established the schools for a reason. And so now making it free for all, in quotes, defeats that purpose, doesn't it?
Well, the point we need to note is that when you are in your little corner doing your own things, you enjoy certain freedoms. And even you have the freedom to think anyhow you want to. That one is not subject to any restrictions. So it is an absolute freedom. But the moment you begin to interact with the larger society, you subject the freedom you have to certain limitations so that others can also enjoy their rights in case there is a clash between two rights. So that is where the balancing act comes in. And that is where sometimes where there's a conflict, we need to bring in the courts to be able to strike that balance, which will be fair, and it will enable each one to enjoy his or her rights to the extent that it will not compromise the ability of another person to enjoy their rights. We know that the Methodist Church was set up. There are other religious bodies also set up. But when they were set up initially, the kind of freedoms, such as freedom of religion, that they enjoyed was almost absolute in that respect. But the moment that interaction comes in, where you open up your school to government involvement, and when you open up your school to admit other students from other faiths, you compromise the almost absolute freedom that you used to enjoy. And so that is what the Methodist Church needs to recognize, and to make sure that while it is not to say that their rights should be completely curtailed, and therefore there shouldn't be any room for the practice of Methodism and so on, it should also recognize that other citizens have the right to enjoy their freedoms. And that is clearly stated in Article 12.1, for example, of our Constitution. And Article 17 also talks about non-discrimination, that we should all be treated equally, irrespective of our background, religious background, political affiliation, and so on and so forth. So it is not to actually interfere in or to deny the Methodist Church the freedom to maybe even propagate the Methodist faith to their members or to the students. But, you know, religion is such a delicate issue that if we are not careful, it can create a whole lot of tension and unnecessary trouble within the society. But the bottom line is that religion cannot be imposed. If you want people to come to your institution, there are two reasons for allowing other faiths to come in. Either you want them to be exposed to the Methodist faith in this context, but also to enable them not to give them the education that will enable them to stand on their 2 feet, become students who at the school, and will lay the foundation for them to, attain their full potential and to be able to acquire job opportunities and contribute to the development of the society. So while they come in, they are supposed to, the church will expect that. They will respect the doctrines and beliefs of the church. and at the same time not practice what other faith they are bringing in. And so at the end of the day, that balancing act should make sure that there are certain practices on the campus that the non-Christian members should take part in. But also when it comes to certain specific fundamental practices of the non-Christian students, they should also be given some room. And through that, they will be able to create that tolerance and respect for each other's freedoms in such a way that it can create that enabling environment on the campus for students to enjoy their rights and freedoms.
Very well. Let me come to the Honorable Isaac Buamanyako. This is quite an interesting one. We've lived together in how nations have run schools, government is taking over those schools, etc., etc. What are your initial thoughts about this particular matter?
Right. Thank you very much, Salom, and a very good morning to our cherished viewers and the good people of Afenyo constituency. And good morning to my brother. It's been a while.
Yeah, long time.
He's in his Liverpool element.
Yeah,
Liverpool's in crisis.
Probably ready.
Crisis.
You know, Salom, it's very interesting reading and hearing of this development regarding a suit against Wesley Girls. And I've been listening to some commentary around it, either by legal people or ordinary non-legal minds, as to what is the real motive of the suit and what will be its effect on our educational system in this country. Because we've been in this country for quite some time now. The churches have played a significant role in enhancing education across this country. And so where you have major developments like these that try to push the churches or the missionary schools into a point where it's as if we are having a religious conflict, then it becomes a bit worrying. From the legal point of view, of course, someone is challenging the legitimacy of a school to either impose a religious belief on certain individuals who are not of the same faith, and wants the Supreme Court to make a declaration that it is an infringement on the fundamental human rights of those people to practice their faith. But then again, if you listen to the Attorney General, when you read the Attorney General's position, which seeks to side, of course, the Attorney General is a party to the suit and would have listened or looked at the intent of the suit and is of the belief that Wesley Girls have a right to do what they are doing, basically. But I'm looking at it from a pure personal point of view, because I'm a born Presbyterian, okay? I went to Adisadel College, which is an Anglican school. And in Adisadel College, you have various kinds of people coming to that school. We had Muslims there, we had atheists there, we had Hindus in Adisco when I was in Adisadel College. But then the school had its own guidelines in terms of how we do things religiously. So typically on a Sunday, everybody is marched to the chapel. You go and do your Anglican service. Whether you like it or not, you have to sing the hymns. And then when we finish the church service, everybody goes. If you are an atheist and we are singing the song and you don't want to sing, nobody forces you to sing. But you have to attend church service because it is part of the rules and regulations of the school to go to church service. In fact, with the coming into force of this charismatism, people had come from various charismatic churches. If you want to practice your charismatism, you go to SU. The school allowed you to do SU. And then you can go and do your praise and worship and all of that time. And we lived in harmony. And so, what again do we have? What do we go to school for at secondary school level? We are going for education. We are not going to school to enhance our religious faith or what have you. We are going to school to be tutored education-wise and build our future for the university.
But the character is also important, and religion plays a key role in shaping character.
But the fundamental point is that we go to school to learn.
To learn.
That is the purpose of going to school. The religious issues just come in as part of your training and guidance. And so, of course, if the school has its own belief system, they have their own practices. When I was going to Adisadel College, I knew it was an Anglican school. I was a Presbyterian. Presec is a Presbyterian school. We had Roman schools like St. Augustine's. Methodist had Infantsipim. So if I go to Adisadel College, I know
you
that
agree to be bound by their rules.
Not just agree to be bound, but you already in the known that this is the school and this is what they do. And so we as parents, if you want to choose a school for your child, you should look at all the complexities that are available in the school. And then you choose your schools according to what you think will enhance the totality of the development of your child. So if you are a Muslim and then you know that you have these schools there and you go in, nobody is going to compel you to say, leave your faith. You still remain a Muslim. But then it will be difficult for me to comprehend that you have to now, because you have atheists, because you have Hindus, because you have Muslims, you are telling missionary schools who have their established principles and their established religious stuff to now be building temples for Hindus because you have one Hindu or 10 Hindus professing to be Hindus. Then you create a mosque for Muslims because Muslims have come in and they also want their faith to be practiced and so on and so forth. I think it will be distorting the focus that we have for the schools. As an MP, I've had comments from some of my institutions when children go to school and they are saying, okay, we need to keep our hair because I have a right to keep my hair. And the teachers are like, why would we be entertaining people growing their hair in the boarding house? Because who is going to make sure that they keep it neatly? And so it's a very dicey issue, but it shouldn't be something that we should also let it affect the way we have grown our educational system. People's rights should be respected. So if Wesley Girls or any of these missionary schools have created a system where they are trying to change people from their religious faith, then that for me will be problematic. But if it has to do with the way and manner they run their school, including attendance of church services, and then if you are coming from a different religious faith, they have to make some compromises in terms of, because see, if someone is in school and you are doing fasting, okay, if you are coming from home and you go to school and you come back during your fasting period, your parents take responsibility on you. But you are in the care of teachers and head teachers, and then you are going to do 40-day fasting. And you say the school should allow you to do those fastings, and then if you go and get complication, who takes responsibility for the health of the child in the school? You see, so yes, as parents and as citizens, we should help our children and our schools.
But you see, when we're in school and SU could declare a few days fast. Let's say we are fasting for Wednesday to Friday because we are praying for this or we want this to happen. The schools never stop those things. So why do you prevent people from fasting because it is Ramadan?
In SU, when they declare fast, they don't give the school notice.
So you're saying if they give the school,
if they are giving
it,
when we go to dining hall and they are sharing food, it's compulsory for you to eat. Yeah. So you hide yourself in the morning to say, oh, they may even give you your food and then you give your food to a colleague.
So because you are fasting.
Because you say you are fasting. If you are fasting without knowledge of the school authorities, they cannot come in and take responsibility when something happens. But when clearly there is a declaration that Methodist Church is saying that they are fasting for 5 days, and so everybody should fast, and then when you are in school, you are telling the students to all fast. Yeah. No, that for me will be problematic. So, and after all, the school setting is for a limited time period. You are in school for 3 years or so at the SS level. When you complete school, you have your wealth and your faith and why. When I finished, I never became an Anglican. I continue to be a Presbyterian. I've moved on to be ICGC. Yesterday, I went for a funeral in an Anglican church. Joseph Boahinedu, Mike Ledus in law, St. Francis of Assisi. And I just remembered the days. I was even a mass server in Adisco. I served mass and I learned so many things from there. But after school, I still went to live my life. And so, please, we shouldn't allow such development.
No, but you see, in your case, which is a good case, a fair case.
Yeah.
But crossing over from Presbyterian to Methodism, it's not very difficult. The basics are the same. Jesus Christ, died, resurrected, etc. Very different from somebody coming from the other side, which is Islam. So you being a Presbyterian attending an Anglican school or a Presbyterian school or a Catholic school, yes, there are some slight differences, but the differences are not as stark as a Muslim, being forced to do that. For the fundamentals in those cases would have been the same.
So that's why I'm saying that the churches don't force. Nobody forces someone to change your religion or your faith. It is just part and parcel of your training in the school to attend certain programs. And that program is compulsory. Yeah. Whether you believe in it or not, it is compulsory. The challenge is that if someone is coming from that religious orientation, how do you create an environment for the person to practice their faith alongside? Because your faith is not being taken away from you because you came to Presec or you went to Fanspring or you went to Adisadel. Nobody will take your faith away from you. But if you are supposed to pray 5 times a day and 6 o'clock is your morning prayers and you are supposed to sleep at 6 and wake up in the morning, wake up at 7 o'clock, you are saying that because of your faith, they should wake you up and go and pray at 6 o'clock. And when your second prayer is 12 noon and you are having lectures, you are saying that they should allow you to leave classroom at 12 o'clock and go and pray. And then when it is 6 p.m. and you are supposed to be on either siesta or come for evening classes or something, we should leave you to go. No, that would distort the general trade. That's why if you are going to an Islamic school, that one they also structure their curricula to accommodate those special occasions. Because when I went to Prempeh for my 6th form, colleagues of mine from Adisadel went to Tia Ahmadiyya. And when they went to Tia Ahmadiyya, they enjoyed the school because every Friday was virtually a holiday because they have to break school at 12 o'clock and go and do their service, and they don't have serious business on Fridays. So they will call me in Prempeh and tell me, Joe, you are poor school. And I'll be in class.
In those schools, were they prevented from worshiping on Sundays? The school made room for them to worship on Sundays.
Exactly my point. But that is because the school have looked at their enrollment over time. They know the number of people who are non-Muslims who come in, and they know that for us to live along and allow them to also, because when people come to school, you also have an intention that they are coming to create relationships. So yes, of course, if for example in Adisadel College during my time, you had admitted students out of a population of let's say 5,000 students or 4,000 students, you have Muslims of about 1,000 students. and they are making a case that we need one classroom
to pray.
With a dialogue or a conversation, the school would have looked at it and said, okay, though you need 5 days, 5 times to pray, they can accommodate afternoon break or something for this population and so on and so forth. But if you want to look at every individual's background and religious interest and say that at the secondary school level, this is where we are going to enforce fundamental human rights for people to practice their faith, as if we are going to school only to go and do religion. It is not for religious purposes that we go to school. And so my submission is that the schools cannot, and they have not, from what I know, compelled anybody to switch their faith.
I see.
The point is that this is how we run our school. You are entitled to come to the school, but every Sunday,
I see.
whether you believe in the church service or not, you go to church.
That doesn't amount to forcing
No.
your religious
No,
practices.
because when you go to church, why? When you go to church and they preach, do you take everything that your pastor
No,
says?
but if I go every day, at least I'll be hearing 1 or 2 things. I may not intend to be convinced.
In fact, it
but
even
the more
helps
I hear,
you.
the more I get
It even helps you to understand the faith base of another
But
religion.
it's not something I want to understand. You can't force me to.
So when you go and they are talking, just listen and let it pass. Why? No, you just go do your 1 hour church, and then there you go.
Andrew. All right, so Mr. Haitu Chega, who is a former Director General of the Ghana Education Services, on. I'll speak to him briefly. Of course, Apostle Emmanuel Okule, who is the GPCC General Secretary, is also on. I'll get to him in a minute. But Council Andrew Apia Dankwa, I mean, it's an interesting debate or discussion. The plaintiff is seeking a declaration that the policies of the school prohibiting, or the policy of the school prohibit the belief, practice, and observance of Islam by Muslim students, and that is in contravention of the Constitution, specific provision of the Constitution they've mentioned. If you model the school such that it becomes difficult for somebody to manifest or practice his religious faith, that is, in favor of another religion. That is, in essence, forcing a certain religious faith on that person. Is that not the case?
Yeah, so, Ellen, wish you yourself a good morning. My friend here, and a good morning. I understand today is James' birthday.
Yes, so
He's the president of the land.
Yes.
So,
yes.
happy birthday. Oh, he's very well.
He's very
But the way you remember the president's birthday,
29th March is the birthday of Nana Akufo-Addo.
Yes, so he remembers.
29th March, 7th October is the birthday of Bawumia.
Okay.
That's why I know the birthday
And
of
8th December is the president of Kufuor.
And 3rd October is the birthday of Alan Johnson.
Okay.
So let me His Excellency happy birthday. And also take this opportunity to wish Christabel Ofoku-Kwarteng a happy birthday. She's privileged to be sharing the same day as the president.
Okay.
Well, so my personal view is that this issue is not about Christianity versus Islam. I don't think this issue is about Christianity versus Islam. I think that this issue is one that is a commitment to rights as against restrictions. It's about the constitution against tradition. It's about the Ghanaian child versus institutional powers. That's my personal view. Now, you see, when you read our constitution, and I think the directive principle of state policy, I think Article 35(5). Now, the people of Ghana, when we talk upon our constitution, this constitution sets an agenda for ourselves. And one of that agenda is a political objective. And the 35 says that the state shall actively promote the integration of the peoples of Ghana and prohibit discrimination and prejudice on the grounds of place of origin, circumstance of birth, ethnic origin, gender or religion, creed or other beliefs. I think the constitution is clear on that. Also, like my learned professor said, I was privileged to have been lectured by Prof. Itua. Very solid. Like he said, and I must say that I agree for this with his position on this. Now, who is even representing Wesley Girls?
Attorney General.
Why would Attorney General?
No, but they've been ordered to file their response.
Yes, so. but it's the Attorney General that is representing Wesley Girls, and Attorney General is representing Wesley Girls because Wesley Girls is considered to be a public institution. So I think there's a bit of confusion because Wesley Girls, like Infant Spring, like Adisadel College, like St. Peter's, like Opukwari, like Prempeh, are all schools that have a religious heritage. But as of today, they are public institutions. And they are public institutions like my own school, Achimota School. Because when you go into the history of education in this country, there was a time when the entire GES budget went to Achimota School because they were a government school. And then the Methodist Church took care of their schools, Presbyterian Church. But then there was a period in our history where GES decided to rope in all these institutions and essentially make them public institutions. You understand? And so because of that, because they are public institutions, then you cannot use that religious heritage to restrict any child in Ghana. You understand? Also, beyond what the Constitution says, I think we must have regard to what the Child's Act says. The Children's Act. And I think that the underlying principle, you understand?
Principle.
Exactly. That says that when you're taking any decision about any child, then the most important decision is what is in the best interest of the child. I think that must be very critical here. And to understand what is in the best interest of the child, the Children's Act went further to then state the rights that children have. So beyond the general rights the Constitution has given us, rights to religion, the Children's Act then went further to give rights which are specific to children. I think one of those rights is the right for the children not only to practice their religion, but even to share their opinion in the children. I mean, when you read Sections 3 and Section 11 of the Children's Act, a child has a right to practice their own religion. You understand? So I think that an appreciation of this must be the basis for which we make this an analysis. For me, it's not about religion. We want to develop the children. We want to develop them not just in terms of their head, but also want to develop them in terms of their heart and their hands. And so you're right when you're saying that, when you said that the focus of education is not just about developing the intellect, but also developing the character. Yes. And that's why we have a peculiar education system that you struggle to find anywhere in the world. The fact that our public schools are generally boarding schools. Now, if that's the case, that means that the focus of the schools is not just what they do between 8 and 2 o'clock, but what do they do beyond
the 2 o'clock?
At 2 o'clock. And I think we will be building a very weak country if even at that stage in how we run our schools, we so cease that more or less separate us as against uniting us. Because the fact that we have lived in harmony all this while is not because it's only because people have decided to be very quiet about their rights. You understand? And if I take what happens in Achimota School, then we can replicate it, because in Achimota School, apart from the Rasta issue that came that last time, when you go there, the Catholics have their own church service. The Protestants have their own church service. The Muslims are allowed to also have their own what's called. So on a typical day, so on Friday they go as in, they typically have their own worship. They found a way of fitting that into how the school.
So on Sundays, for example, church service is compulsory.
No, so on a typical Sunday, the Catholics go to their mass very rarely, like 6. So let's say I was a Protestant. So by the time I'll be going for my church service, the Catholics would have finished theirs and will be in the.
So you don't have a general service?
No.
As is done in other schools. Achimota doesn't have that.
So I finished in 97. I think it's still the same now. You understand? So we went. So they had a Catholic. They went for their service. We had the Protestants. So the Protestants consisted of all the non-Catholics. We had our own service, and the Muslims also had their own what's called
service.
So for me, if as a people, we have decided in our constitution, like in the political objective I said, to integrate all of us, then I think it will be a feather in our cap if in our schools we allow for an expression of this identity.
So I get a point about the schools having been taken over by the state now, but the schools are allowed some privileges or some, for example, in some schools, I don't know whether it still holds. You cannot be headmaster or headmistress unless you come from the mission that established the school. Even to be SP, you must belong to the school, the mission that established the school. All of that. I don't know whether those things still hold. So that is an acknowledgement of the effort that those missions made in establishing the schools. In fact, if those missions hadn't done those things, I don't know which schools would have been relying on now. Many of the very good schools are mission schools. And perhaps they are the best because they were taught or they trained the people well. And today we see them as the best and the state has taken over them. So if we allow it that way, what do they gain? What do they get in response or in exchange for the investment they made in establishing the schools?
Selom, I can tell you on all authority that the issue about they restricting who is headmaster, all of those things, is there because nobody has challenged it in court. I'm telling you, until this matter went to court, I'm sure they were restricting other faiths. You understand? So it's only there because nobody's has challenged it. But if they challenge it in court, they can't say that unless you can only become headmaster of, let's say, infant school if you are a Methodist. You understand? And their proud heritage, as in their what's called their heritage of excellence, is not only because of their Christian faith. So are we saying that?
With the discipline, the training,
exactly,
which is rooted in Christian faith.
So are we then by extension saying that if your faith is Islam, then you struggle to have a heritage of excellence? Adisadel School isn't a religious school. I know my brother here won't agree. But I can state that it's the greatest school in this country, but it's not a religious school. Adisadel School is not a religious school.
But the point is, that when you look at maybe a scale of, about 20 schools, 20 so-called top schools in Ghana, more than 60% of them will be mission schools. And there should be a reason for that. But
now, since about the 60s, the government has funded them.
Yeah, what I'm saying is, there should be a reason why we consider them as the best. It's perhaps because they have instilled some amount of discipline, which is conducive for excellence and for academic,
So let's take Presec. Let's take Presec Legon. There are about 1,000 Presecs. Presec Legon, Presec Legon.
So how many?
Why is it just about 99% of the Presec schools are not at grade A.
At that level, yeah.
So it's not about they are not good or excellent because of their religious background per se. You understand? In fact, most of these schools, Adisadel 1905, infants from 1876. At that time, almost every boy who was sharp and wanted to go to school, they didn't have a choice. They had to go to either infant frame or Adisadel. You understand? And so over the years, they had that because of scarcity. Yes, they had a pick of all the best, and they've built a heritage of. And right now, most of the top schools are because of their pedigree, they attract the most intelligent students. So it's more or less garbage in, garbage out. So for me, it's not about the religion. We want to build a country where we are really and truly integrated. We want to build a country where rights of citizens are respected. And one of those cardinal rights are your right to express your religion. I'm a Christian. In fact, I'm a born-again Christian. You understand? But I don't think the fact that I'm a born-again Christian, I'm a Christian, I have a right to limit, let's say, my brother Hamza from practicing his faith. And I don't see how that takes anything away from the ability of the schools to keep discipline. And also, I'm giving a typical example. That when you go to Adisadel School today, they found a way of allowing an expression of all these religions, and yet discipline hasn't broken down. The schools shouldn't be seen to be restricting people's expression, because then they'll be discriminating. Yes, and then they'll be flouting Section 8 of the Children's Act, which says that the children should be allowed to develop in dignity. So if I can't express, I can't pray. You understand? If, let's say, I can't pray only because I find myself, what kind of information are they telling my young mind? And that's why I said that in analyzing this issue, I think the most important thing is Section 2 of the Children's Act. What is the best thing? Because the fasting issue has been brought. For me, my question when it comes to just the fasting issue, the in periods of Lent, because we also know that there is Lent. So when you go to Adisadel College, there'll be Lent. When you go, what the schools do they allow them to fast? I'm sure it's no. They allow them to.
No, I didn't.
You understand? So the question we should watch, we are during Lent period.
What do they do?
What do they do? Do they so-called, if they don't allow the children to fast, especially in Lent, then at that point, an argument could be made that
it is not about Islam.
It's not about Islam. It's a policy, and for them, in their view, it is in the best interest of the children not to be starving. You understand? And that's why, for me, I don't want us to make this issue about whether it's Christian
or Islam.
At the end of the day, they have a religious heritage, but they're all public schools, like Achimota School now. They're all public schools.
Yes.
GS gives them gives Achimota School same budget like it gives Adisadel or Wesley Girls. So immediately we start looking at it from just the religion. Then I think the confusion will be creating as an. Let's look at this issue within the context of the Constitution and within the context of the law itself.
Very well.
Just a short one. You see, the Constitution makes provision for so many things, but it takes time for some of its implementation to crystallize. So, as you rightly indicated, we have all these rights in there. It takes some development over time to ensure that all these rights are put in place. So the question that one may ask is that at this material moment, are we getting to that point where these rights have to be clearly established? And I am of the candid view that we have even long gone past that stage. That right should be, and I have a little, maybe you may want to go and come back.
Yes.
But
so let me just go and come back so you express your difficulty. Mr. Charles Ahetu-Chega is a former Director General of the Ghana Education Service. He, I'm sure, has dealt with many of these. I don't know how he dealt with them, but he's joined us to share some experience with us. Mr. Ahetu-Chega, good morning. Welcome to the program. It's a pleasure to have you during this discussion. You have been at the Ghana Education Service for a long time, rising to the very top. Obviously, this is not the first time a matter like this has come to your notice. How did you handle them in your time?
Well, thank you, Selon. I think I'm actually tuned to the program, so I'm listening to all the arguments that have been discussed here. So I am actually a part of the discussion going forward. And I've listened to the various views that have been shared, but I'm going to share a dimension that none of your
panelists.
Your panelists has actually raised. And that this goes back into some level of historicity and trying to create a context for all of this. Now, if you go into the history of education, you see that all of these things evolve, and the role of the Christian church in shaping education and the government adopting education, and then there comes in. Now, I heard one of your panelists, who is a learned person, say that...
we have four. All three of them are. We have a prof, and we have two.
Yes. All three, I know. Okay, all three are. Good. So, salute my learned panelists. Now, so you have this situation where you have the public now entering education when, in fact, the churches have already gone so many years ahead of them. Now, so let's fast track this history and come to this. But I want to put one thing inside. Now, the significant aspect of this whole history is that in the relationship between the government and the mission schools, there was a particular agreement that was signed. So you cannot say that, of course, when they receive assistance from government, they are public schools, so to speak, fair and simple. But there is a partnership agreement between the churches and government in the management of those schools. So when you come to the whole debate about, the mission schools are public schools, so public schools, no, that would have to wait a little bit, because then we have to go into the details of the partnership agreement, which defines how government relates with the schools. So that is one part that I'll leave that. But let me come to the policy aspect. Now, I can say for certain and without fear of contradiction that In education, we have never developed a religious policy. We don't have a religious policy in education. Anybody who can correct me if he or she knows. But what we have close to a religious policy is the categorization of schools into two groups. And I'm sure many of you remember, there are two groups. One, non-denominational schools, and then mission schools. Those are the two categories that we have. Now, most non-denominational schools are public schools, especially at the secondary level. At the primary level, we set it up, yes, but that is not what we are talking. At the secondary level, so you have a non-denominational school like my favorite Winneba Secondary School, and you have a mission school like Wesley Girls. The two are not the same. The conditions under which they operate are not the same. I'll give you an example. In Winneba Secondary School, we will not have any what we call structure representing any mission, any religious group in that space, which means that we don't have a church, we don't have a mosque, we don't have even a small shrine anywhere in any corner. It is forbidden because the school is a non-denominational school. Now, when you go to the mission schools, they already have a partnership with government, and so they can establish their churches, to build their churches and all of those things. Now, I don't know whether they envisage one day that some other groups will come in, but they don't create opportunities for the building of, let's say, a mosque or a shrine in their religious space. So that is the point from which we depart. Now, let's come to the other things. Now, when you get into the schools itself, one of your panelists talked about scripture union. Now, the scripture union was the small inroads into the mission or the religious discussion, because then it allowed the what we call the charismatic groups to enter into that space and also do their own thing. That, as one of them said, truly, they also created a space for themselves. But largely, it was the mission. If it was a mission school, it was a mission that existed. Now, in the non-denominational schools, you could have SUs and any religious organization that anybody wanted to form, and you were allowed to operate. But you don't normally find many of them. When I was in school, we didn't have any Muslim group in my school. We had SU and some affiliated Christian religious groups. So you see, when it comes to the concept of freedom of religion or freedom to practice your religion, that is a very difficult concept in education. It's a very difficult concept because the school is a system. It is programmed. We manage every second in schools. So when you structure the school system, you have a time when students should be in a particular place at every time. So it then becomes some very interesting reconfiguration to maybe slot in what we are discussing here as freedom of religion. I'm yet to properly understand it in terms of the coherence that we want schools to have in terms of their religious practice. But again, it does not stop anybody. And I'll give you Winneba Secondary School again. In Winneba Secondary School, your Sunday morning was free to go to anywhere you want to go and worship. So for students who want to go to town to go and worship, maybe in their churches in town, they received exeat and off they went. I don't know of an experience where religious Islamic students were able to go and join their colleagues in town. But of course, if they were there, they would have been allowed to go, because it is a non-denominational school, and those of us who are in other Christian groups will go and worship in the classrooms and do our prayers in the classrooms. Now, so there was an opportunity for you to do what you wanted to do. But then we had one activity in the school, just as they have said, where everybody must gather there. You must be in that place as a student. And that is the one that my colleagues have been calling church service. We call it church service for the want of a better description. But in that church service, it is actually a church. It is a gathering place where you don't have only a Presbyterian priest preaching, you don't have only a Methodist priest preaching, you don't have only an Anglican priest coming to the school to preach. You don't anybody can come and preach. And then on we went. So that kind of practice exists. But it is not the same as in mission schools. In mission schools, they are established by mission. They are in partnership with government for various reasons. So it becomes very difficult for them to suddenly adjust to a shake-up that will allow them to incorporate all of the emerging issues about religion that are coming in our modern day parlance. So, as somebody said, a lot of patience and time is required to deal with this. And especially as we talked about the local parentis issue. If you talk about local parentis, there's a huge responsibility on schools. You know, where you don't take the children for granted. You don't do anything that you want to do with them. You must really be a parent for them in school. So you don't just allow them to do anything. If you observe that some group of people are fasting and they are seriously fasting, you will go in and question them, why are you fasting? Because you don't want a situation where a child will break down during maybe a morning assembly or when girls are sitting down and doing their morning assembly, and then you go and realize that the guy has been fasting and she already has a problem with ulcer, and then it gets complicated. And then immediately parents will jump on the head of the headmistress, and then there's chaos. So those are things that we need to balance and appreciate with each other. But I can tell you one thing. My brother from Madisco, I'm sure he remembers, that is the one situation that immediately shook the Ghana Education Service in relation to this whole religious discussion. That is when a student who did not go to service in the evening, and then when the master was coming around, we were in the classroom, when the master was coming around, the student jumped from either the second floor of the classroom block and landed and died. Now, that was a real wake-up call for us to begin to look at this situation. Well, we managed to talk about it. We also came up with this same brouhaha, and we managed to ensure it. But it has to state that even though there were Muslims or other religious faiths in mission schools, their situations have been very cordial. And none of them have resisted or announced or demanded that they wanted specific religious rights or rights to worship their religion, or even they were prevented from doing what was their religion. It has been harmonious all through this time. And so at least I'm beginning to wonder and worry where this is coming up. Now, the second one has to do with our friends and colleagues from Jehovah's Witnesses. Now, you know, at the basic level, they have a Wednesday morning worship. The Jehovah's Witnesses, most of them do not attend. And that also became a crisis at the basic level. And I had to go into just allow the teachers to make sure that don't force the Jehovah's Witnesses. If they say they can't come and join you people trying to pretend that you are speaking tongues or worshiping in some special way, and they say that that is not their way and they can't be part of it, please allow those students to sit in the classroom and separately. You know, so we manage that. I believe that there are still segments of that confusion still roaming around in school. Now, so that for me is exactly how the situation has been. And for me, when it comes to religious rights, as I said, it's a very, very difficult expression in education because, again, it would lie heavily on government to begin to look at how it will expend resources to be able to build those structures in all schools in the country. University Secondary School will not use its budget to build a mosque or a church. If the government wants to promote what I believe many people think is freedom of religious worship, then it will have to provide those things to ensure that people can recognize that their religious rights are being respected. And I taught in a Muslim school, where a predominantly Muslim environment school, where the children, on Fridays, you know, the Islamic worship has a range of time in terms of their worship period. Now, around 12 in the afternoon, when the students normally close, or as my friend said, Tia Ahmadiyya would have closed, inside Boku, we insisted that no, the prayer period extends up to 2 o'clock. we will not allow you to close at 2 o'clock, but close at 12 o'clock, but close at 2. And the students just kept quiet, and they agreed. So at 2 o'clock, the whole school closed, and there was freedom. They could go and pray, and then go to the dining hall, and all. That meant that they would delay dining against those people who were not Muslims, who had to wait for them to finish their Friday prayers before all the school joins the Muslims to go and to church. So it's a very dicey situation when we begin to look at it. When we begin to literally insist on our specific rights of religion without looking at the school context, I think that the government must be ready to revise its 2026 budget and begin to put on the construction of structures for religious worship in schools to ensure that there's a real balance. Because I think that we are heading for something that would require a bit of a serious discussion.
I see. You said a number of things and very comprehensively dealt with the matter. The first one having to do with the non-denominational and then the mission school. So your view is that we must still, uphold this categorization. So, for example, Wesley Girls is a mission school as against Achimota being a non-denominational school. And we cannot expect the two of them to behave the same, even though they are both publicly funded. That's the point you raised, number one.
That's the point I raised.
Number two, you raised a point about what pertains in Winneba Secondary School, for example. That's what you know. Of course, you've been GS boss, but you are familiar with Winneba for obvious reasons. So if a philanthropist, or maybe a church or an Islamic group, wants to build a mosque or a church on campus, given that you said no religious group was allowed to build those facilities in the school because it was secular, would you allow such a group or philanthropist to make such an investment in a mosque or a building that can be used for church, for example?
That matter came up to me when the Adisadel case happened. And we had to discuss that. And my position, I still hold it. I say that allow the non-denominational schools to continue to be non-denominational schools. I cannot supervise the building of a church in University School. I would neither supervise the building of a mosque in University School. In fact, during that period, we were still going through the transition of colleges of education being under the Ghana Education Service when they were training colleges. So I was very upset when the principal of Accra Training College called a mosque to be built at Accra Training College, because I said that he had violated the non-denominational nature of most of our non-denominational colleges of education. Because when you do that, then you begin to allow specific interests to come and explore opportunities to create or deepen the kind of division that we are even talking about. So I say that let us allow the non-denominational schools to have non-denominational structures. Other than that, I would say that if you want to build a mosque, please, you must build a church. Or I will have to get somebody to you to come and build a church. Because there is no way we would have to tilt the balance in terms of the non-denominational nature of the school in the interest of any religion.
I see. That's interesting. Very interesting points you raised. Now let me speak to who is General Secretary of the GPCC. Hello, good morning, Apostle. Welcome to the program. It's a pleasure to have you. Yes, we see that this matter is not making your side of the divide or your side not particularly pleased. Is it a case that in so-called mission schools, persons of other faith are prevented from practicing or manifesting their faith?
All right, thank you very much, and good morning to yourself and the panelists, my colleague panelists. I want to start by agreeing with a couple of things Mr. Chiga mentioned. I think we should be clear in the category of educational institutions we are talking about. As he mentioned, I put them in 3 categories. That is the private, purely private, where I build my school. Government has nothing to do with it. I own my land and I name my school. I run it throughout the year. Government doesn't put a dime in it. Then we have the missions establishing their churches. Government is partnering them, is providing support. Government doesn't take over. Government doesn't take over. It still belongs to the missions. And then you have the purely government schools, like Laboni, like Winneba, like Putan Secondary School, and others, Achimota, and so on. I think we should be clear about this categorization and what it means in terms of ownership and values. The mission schools have been established for a reason. The missions were running them anyway without government support. And it was government responsibility to establish these schools. So I think it is in the wisdom of government, knowing that these mission schools or missions are doing something I should be doing. It is fair enough if I partner them and support. Government comes in to take up the fees of teachers and so on. Remember, to the extent that the missions also establish teacher training colleges to feed their institutions. And so the missions have a very comprehensive approach to what they are doing. Government coming to partner doesn't make the missions lose their ownership, and we shouldn't forget that. And so I think from that position, the missions have a very, very significant role and influence. And by the way, the constitutional provisions for freedoms, there is no freedom or right that is absolute. It doesn't, even in my own house, where I bought my land, I got an architect, I employed masons, they built my house and I fenced it with a gate. My freedom in that house, to the extent of being in Ghana, is not absolute. There are things I cannot do in my house. It belongs to me. But if we are not careful, we want to make it look like some people are being discriminated against. No, I don't think it's discrimination. I think there are boundaries that we must respect. After all, the mission schools don't say that if you are not a Christian, then we don't admit you. We will admit you, except that as an institution, we have our own guiding norms and principles. And then the other point I want to quickly make is that the Constitution also provides for institutional rights. The Constitution of Ghana doesn't provide for only individual rights. Institutions also have rights. And so institutions that are set up with a particular mission, particular values and norms. I can't go to, let's say, the military or the police and decide that I want to do something the way I want to do it as part of my human rights. They have guidelines. I can't go to GBC or GTV, and because it's a state-owned institution, I want to do anything I want to do as part of my human rights. There are boundaries and institutional norms. And so whichever way you look at it, freedoms and rights I want to establish are never absolute in any way. That brings us into the national setting, where the missions have set up the schools, government is partnering them, but there is a reason why the missions set up the institution and government coming in. And so government recognizes, the ownership of the facility. And the other religious persons who come to the mission school, they are not prevented from practicing their religion. But for institutional coherence, for the institution to be held together, for there not to be chaos, where one person says, I do this, another person says, my religion says this, and another person wants, no, for institutional coherence and consistency, the institution must necessarily have its own values and norms and how it wants to.
How about the issue of fasting, for example? We all know that Ramadan is a very important part of the Islamic faith. So, yes, I'm talking about the issue of fasting. One of the matters is that in Wesley Girls, Muslim girls are not allowed to fast. And that breaches a cardinal pillar of the Muslim faith or the Islamic faith. How do we address that as well? I mean, there's the month of Ramadan.
So-
The whole world knows that Muslims fast. But in this particular school, you will not allow them to fast because it is a mission school. Is that the case?
Yeah, so earlier on, I think you gave the example of H and how sometimes you decide to fast for 3 days. You see, within those periods, when it is dining time, when it is time to go for dining, necessary you go to the dining hall. You go and sit, and like the Honorable MP said, either you find a way of giving your food to somebody or you don't eat at all. You take your food out of the dining hall if you're allowed on that day. You take it out of the dining hall. You know, so the fasting bits, these are underage children. They are not adults who are by themselves. And that is a constitutional rule that to the extent that they are underage, they must be under guidance. And I think it has been said, I've heard my colleague General Secretary of the Christian Council explain that that issue wasn't, the rule wasn't made even for non-Christians. They instituted the rule in the mission schools for Christians because, in fact, I must say, not in terms of comparison, but a lot of today's Pentecostal and charismatic churches, they do more fasting than what our brothers and sisters in the Islamic religion do. And our children are expected to come along. So if you are in the school under the guidance of teachers and you want to do a fast, I think it has been explained that we will prepare having a note from parents saying that please allow my ward to do the fast. Any outcome or incidence of problems, I take responsibility for it. You know, that way the school is also covered, if the school allows it. I think we should negotiate this. And maybe my last point on this quickly. I heard the Honorable MP make a very fantastic point that if, for example, you have 500 out of 1,500 students being of a different religious persuasion, even in a mission school, the parents of those or that religion could, in a nice way, negotiate with the mission authorities that please, because of this and this, can you allow our children to have a recognized place, maybe a small structure? That can be negotiated, given numbers. But you see, it shouldn't be the case that because I step into an Islamic school or my child steps into an Islamic school,
You demand that this is your right.
Of the Islamic school should be changed. No, I don't think I'll go with that. So I think most of my points have been made by earlier speakers, and I want to...
Very well. We are grateful for that. This is a big issue on 97.3 City FM, and of course on ChannelOne television. We are looking at the matter of the Osman versus Wesley Girls, asking whether these are human rights violations or institutional independence, matters of institutional independence. Let me read this message from lawyer Chris Akumi. He said, good morning, Salom. I accept fully the concept of compromise as advocated by Professor P.J. Tuah. The balancing proposal is the way to go. However, we must draw the line between freedom of religion or worship and practice of religion. The practice of religion must not be strictly enforced in Christian or Muslim schools. If you choose to enter or study at a religious denominated institution, you must be prepared to go by the rules and practices of that institution. You have elected to go there since there are options. And you say cultism is a religion. And in Angloland, it is called Yever. Are we saying that in the name of freedom of religion, we should allow practice of Yever or Atigari in schools, particularly Muslim or Christian schools? Right is not the issue as guaranteed by the Constitution, but compromise is. That's lawyer Chris Akumi. Now, Togbe says Juma is not compulsory, or Juma is not compulsory, but the 5 daily prayers are compulsory. As per the argument ongoing, does it mean Muslim students will leave their class to go for these prayers, and even when class is ongoing, or class will stop for them to go and have these prayers and come back? The argument of Wesley Girls from the outset has been that they do not support the girls irrespective of the religion they belong to engaging in fasting due to health concerns. Thus, to now anticipate that the school will institute requisite measures to support such an activity poses a formidable challenge, one to which they have no intention of acquiescing. Do these mission schools belong to government, or government is partnering them to educate the children? Okay, so what does the TOC in government coming in to provide funding for these schools? Okay, not quite clear. But the government compensate them if we claim these schools are public schools in compliance with the Ghana Constitution. This one from Jones Adoboinla says, "Good morning, Salom. I don't think we need to debate about the Wesley Girls issue. When you go to Rome, you do as the Romans do. We sometimes create unnecessary tension about issues that can easily be settled. Let's stop this and think about the betterment of the schools." Well, these are views expressed. I'll take a concluding remarks on these, and then we go ahead. So balance is the name. Negotiation is it. It is. But negotiation, if you are negotiating, it doesn't necessarily mean you have the right. You are trying to persuade a person to get you something. Is that not the case? Yeah. But that's what they say cannot be. And I don't know what to make of the Attorney General's position, that despite the fact that they are publicly funded, they reserve the right to maintain or retain their identity as mission schools. And so the mission schools are right in doing what they are doing.
Yeah, so, Salom, one is good, the case is in court, because some of these matters, you need judicial pronouncement to settle it and give guidance. And so I'm all for testing the Constitution in matters like this. And I know that in terms of interpretation, the courts always avoid absurdity. So the court will be guided by all the facts from whether all the institutions, and then they'll make their determination. But for me, my concluding remarks will be that as a country, we are not in crisis in terms of religious tolerance. We are very, very religiously tolerant. And in fact, we respect ourselves from Christians to Muslims and all other religious groups, that when we overstretch one or two of these matters, it creates unnecessary confusion, as if there is a religious battle or a religious matter between the parties. The point is that children are in school, and that's my position. Children are in school fundamentally to be trained academically. No school should put in place a mechanism to compel anybody to switch their faith. And I have said time and again that no school in Ghana today has that inclination that they are going to compel anybody to change their faith. That one, somebody has to prove to. And if you look at the claims that the person is making at the Supreme Court, he is only trying to enforce someone's fundamental right to religious practice, such that, yes, though I am entitled, I'm in this school, it's a public school, I am a Muslim, give me an opportunity to express myself. So the schools understand that you're a Muslim, you can practice your faith, but how do we create the enabling environment? And that can only be done by further engagement and consultation, and also, as I said, the numbers. Because you cannot be handpicking individuals in an institution and create spaces for them. It goes against coherence, training, discipline, amongst others. And so for me, it's an interesting matter. We are all one as a country. We need to build this country with a lot of tolerance. And I believe that the various positions that the Methodist Church, the Christian Council, if you read all their publications, they are only trying to establish the fact that government is here to partner us. We have established our schools based on certain values and principles. please allow us to keep to those standards.
Were these not the reasons why government took over those schools? Or
No, government took over those schools because one, there were challenges in terms of funding. So, and then in trying to broaden education access, you thought that, okay, why not take up some of the bills of those schools and then allow, because, and I'm even thinking, and that's a big one, maybe this big issue. Is government ready to allow the mission schools to take back? It's been a conversation on the table. And government has always been careful allowing the mission, because I think if we push this, we stretch these things, we will come to a point where the mission schools will say that, and let's do fee paying. Let's take over our schools, pay our teachers, whoever wants to come and pay, and then, but I think that is not where we've got into. And so let's see how it goes.
All right, Andrew, your concluding thoughts on this.
So I think that, like I said, in my personal view, is that this is not about Christianity versus Islam. For me, I think we are being pushed to relook at our education once again. Because this issue about whether or not the mission schools will take, if they are pushed, I bet you, they'll just go for the jewels in the crown. Methodist school will just go for Wesley Girls and we will leave the other Methodist schools. Presby will just go and take Presec, he will leave the other Presby schools. The Anglican will just go for Adisadel School, probably St. Monica's, and leave the other, you understand? But I think it's an opportunity for us to relook at our own educational system in terms of the categorization and all. I listen to the other respectfully. Now, are we saying that so right now, when you take the so-called mission schools, what are they? Are they mission schools or they are public schools?
So that's a special category.
But so then why is Attorney General the one? Because Attorney General
that's why they've been asked to respond.
Yeah, but they are the counsel. They are counsel for the mission school.
Yeah, but so we don't know whether Attorney General entered appearance for them. But for the court,
was joined in the suit.
Yeah, for the court to order Wesley Girls to respond, then it means that Attorney General necessarily may not be representing them. I don't know.
But I understand Attorney General was joined.
Yeah, he's a party to
the suit.
Okay. He's a party to the suit.
Because it is believed that it is a public.
Even if yes, it may not be 100% public, but even if it's 1% public, then he has a stake in there. And we know that state funds those schools.
Is it 100% or 20%? You see, that was that we need to relook at.
Yeah, but you see, you can't also discount the ownership of the school or the should I say the initial ownership of the school. Once you did not pay them compensation, etc., we don't even know how it happened.
So I'm not discounting the heritage of the schools. What I'm saying, because they are public in nature.
That's why Attorney General is saying.
But then that then means that in how they are run, you can't say because your heritage is religious based, then you have the right to restrict under Ghanaian.
But if we pick from where Prophet Dr. Ayato Chega came from, he said these mission schools have an understanding, have signed some understanding of government. So government affirms their position that yes, though we are coming in to support you, we still give you some rights.
Exactly.
Okay. Understand. And those rights, and it includes those churches also funding a part of the schools.
So those rights oversees the constitutional rights and the rights of the children under the Children's Act. And that's why I'm saying that. And that's why I was saying that I'm brought the issue of the length. You understand?
Because I think now it's becoming obvious from all that Mr. Chega and Co have said that the issue of fasting is one that schools generally frown upon because of the local parentis matters and all of that.
Exactly. So then in that same light, see, we'll have a problem if, let's say, in a Methodist school, the Methodist practices are allowed, or the children are allowed to practice their Methodist practices, and then other children who have different are not allowed.
So, for example, if the Methodist Church is declaring a fast, would the students be made to practice or
exactly.
to partake in that? That would be
or
interesting.
even beyond the fasting. I think right now it's clear that during Lent they don't fast. So the fasting issue, no Muslim can go and say that I'm being discriminated against because I was not allowed to fast. But the other Methodist practices. You understand? So if you allow the Methodist students, let's say in the Methodist school, to partake in their Methodist, some of their Methodist practices, then
these schools are not practices.
No, I'm making a point. I'm making a point.
I think it's making a hypothetical point.
Let's not be hypothetical. We should talk about the realities in those schools. So unfortunately, you didn't go.
Fortunately,
unfortunately, because in all of these schools, my brother went to Infant School. Okay. My sister went to Wesley Girls. In all of these schools, there is no fundamental teaching.
Doctrinal
teaching.
No,
it's just about you knowing that if it is Roman school, like St. Augustine's College, when it is Sunday, you go to church service.
You don't use a rosary, you don't do those things.
No. They will not give you rosary and tell you to. No. So you just observe those things, the hymns and all of this. So, and build it up from there. You can ask around all the schools. There's no doctrinal teaching, but because it's a Methodist school, you'll be singing Methodist hymns. Hymn dance. Because it's Anglican school, you'll be singing Anglican songs.
So it's only the hymn that makes you Anglican.
It's only the hymn that makes you Anglican. And they're preaching by the father. If it is Roman father, the father will come and do the Roman stuff.
So
let's not let it be as if there are new doctrinal stuff that changes the mindset of
Dogu says, I went to Infant Spain. We never engage in fasting. The issue in discussion is about fasting and not about general practices like prayers. The school has not stopped them from praying. So we incessantly discuss upon the state's assumption of control over the schools. Yet the query persists: did the school duly compensate these mission institutions as unequivocally mandated by the Constitution? That's interesting. Is Mr. Adisadel still on? Hello, Mr. Adisadel. Okay. Yes. So yeah, what's your concluding thoughts on how do we? What should we do moving forward to accommodate everybody so this doesn't become an issue?
Well, I think we have built a consensus around discussion or collaboration or negotiation, as we call it. And I am of the view that it is important for us to go in that direction. But it is important also for let me use the word stakeholders to really appreciate that when we begin to talk about the local parentage for the schools, there are a real local parentage in terms of funding needs. So while the girl is in school, there are certain acts that she cannot perform because this is a parent saying, no, you can't do it because it could probably cause bodily harm and some of those things. In other words, schools represent the children we have, and that is, we are not adults, we are deep. So as much as possible, it extends beyond that at on. When you go around the whole issue of practice, then there are interesting things that come up. And maybe I'll also add to close my conclusion thought is that as much as possible, because we do not do doctrinal issues in any school, the churches don't do any doctrinal issues apart from the fact that when we go to the Catholic school, when the particular state holiday, the school will be on holiday for the mission schools and other public schools will still be going on with their classes. There's a need to try and bring about some harmony all of these things and ensure that we work together and allow our children to grow up learning and then develop their faith in the course. Thank you.
Very well. Most grateful. Let's take this, Adam, these few messages. Mumuni Isifu says, good morning, Salon. Please, I need some clarity. What exactly is Wesley Girls denying the Muslim girls from doing with regards to their faith? Isaac Park says, does the military allow the wearing of hijab on their uniforms? Why do you want it at another person's institution. Says, on the fasting, my take is that Wegehe shouldn't force them to eat, but also not make the parents sign a form that the school cannot be held responsible should they faint or something, happen to them. Okay. All right. So these are points. Yes. We've been joined by Dr. Sai Kwapon, fellow at CDD, of course, for the other discussion. But obviously, he has a take on this. Doc, good morning. Welcome to the program. Interesting discussion so far. What are your thoughts from a governance viewpoint, from a human rights viewpoint, from an institution viewpoint as well? Hello, Doc. Oh, okay. If you can unmute, so we take your view. Well, I think Dr. Saikwapo is having some difficulty. Okay, just before we go, yes.
Like, let's take the hijab. Okay, it's a critical.
It's a big discussion. From here, I'm sure the next stage will be the hijab. In fact, it's all put together. It's all put together.
You know, so why would it be difficult for, let's say, a school to deny someone that kind of dressing if it doesn't affect the training of the child, but as part of the religious expression?
Yeah.
Okay. People talk about weather and then the heat and all of those things. But if not for those reasons, and it should be legitimate reasons why you would deny someone that entitlement or right to put on a hijab, because that goes to the core of a religious practice, and that shouldn't also be seen as when those denials come, then I'll have an issue.
So the dress code, so the GPCC, for example, talk about dress code. The GPCC, for example, says that they are not denying anybody from being in the school, but the dress codes in those mission schools, must not be disregarded, must be followed. So as part of the dress code, you don't wear hijab. You keep your hair short, you wear your uniform and everything. That's how it should be. That's the case the GPCC is making. That is part of the dress code. So wearing hijab.
How is it different? How is it different from the Atonta Rasta case? How is it? Because in the Atonta Rasta case, the school's view was that, listen, as part of the code, you must keep your hair short. You understand? And yet it was held that the child had the right to keep the Rasta because, and so if that's the case, then
because of religion.
Religion
this
to
is
keep
more
hijab.
Religious.
It just has to be in the blue and in the yellow and green color of the school.
Very well. Okay, the hijab. So perhaps the school will have to procure hijabs as part of the dress code. Maybe.
Because we must be
interesting. We'll take a short break. When we come back, we'll delve into the discussions of the happenings in Parliament. This is a big issue. Your views are welcome via WhatsApp line displayed on the screen, 020-444-7033 or 054-9986-996, 97.3 City FM, ChannelOne Television on YouTube as well. My name is Salamado and we'll be right back. You're welcome back. This is a big issue. We are on 97.3 City FM. We are happy to have you join us. Now, we move to issue 2, Parliament. The first discussion was a bit somber, but this is Parliament. Speaker of Parliament, Abang Babin, has clarified that the Banda parliamentary seat cannot be declared vacant despite a High Court ruling that annulled the 2024 election results and ordered a rerun within 30 days. Addressing the House on Thursday, November 27, the Speaker explained that although the ruling overturns Matthew Nyindam's election, the law imposes a mandatory 7-day stay of execution on all appealable High Court decisions.
The ruling of the Tamil High Court was delivered on the 24th of November 2025. The statutory 7-day stay therefore remains in force until 1st December 2025. During this period, the High Court's ruling cannot form the basis for the Speaker to instruct the clerk to notify the Electoral Commission that the Pandai seat is vacant.
All right, that's the Right Honourable Speaker of Parliament, Abambabin. The minority in Parliament has sharply criticised the Tamale High Court Judge Justice Emmanuel Bruplanche, alleging that his handling of the Banda election petition amounted to judicial irresponsibility. Minority Leader Adisadel College says the caucus will resist what it describes as an animal farm judgment intended to remove the sitting MP before the full appeal process is completed.
A judge who spent minutes walked out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we have now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic.
Well, that was Minority Leader Afenyo-Markin, of course. So yeah, I will come to the second part of the discussion where the Speaker referred him to the Privileges Committee. But let me start from you. Your side doesn't appear to be enjoying a lot. I mean, your seats, continually come under threat. There was Akwetia and there is Banda. Of course, we don't know who will win.
It started
but
from
it's
your friend Ablikuma.
So your macro minority is further being chipped away. The status, I don't know whether you get to nano minority. I don't know, but of course your general thinking. The court has made a decision. Of course, but I mean that's law. 7 days after the judge, it's only after 7 days execution can start. But what's your thinking generally? I mean that's sound law, but eventually by Monday, Tuesday, should his seat be declared vacant?
Well, first and foremost, I think as a caucus and as a lawyer, we disagree with the judgment of the High Court. We think that the court erred both in law and in fact that was available to him. But that is judicial process. Someone took the case to court, challenged it as provided by our constitution, and then the court has made a determination. You also have a right of appeal, and so we have triggered in our appeal to the Court of Appeal and then applied for a stay of execution so that we can have finality to the matter at a higher court. What we are only seeking for is that the matter for the stay of execution will be heard swiftly so that at least the matter can continue at the Court of Appeal. Because we've appealed against that decision, and unfortunately we've not even been served with the full facts or the judgment of the court. But when you look at the reliefs that the person sought for and the judgment that the court gave, that is what makes us feel like the courts now appear to also be doing something that is worrying. I'm not a firm critique of our judiciary, because in time past, when the courts were also giving judgments in the favor of NPP, so-called, we had the NDC people complaining bitterly that it has become a unanimous FC. Okay, now over just this past month, it has shifted. And so now it appears like every matter that goes to the courts is given in favor, that political cases are given in favor of the NDC. But that is why you have a right of appeal. And so we go in there to test the law. Now, for us as a minority, we are not intimidated by the numbers that they are taking. Of course, we wish we had more than enough, over 100 and the rest, to take government on. But even with our dwindling numbers, I think we are doing phenomenally well by holding government accountable. And even with their super majority, we are not feeling too much as to its impact in terms of governance and then parliamentary practice. But what is ours, we need to protect it. Ablekuma North, for example, we had won that election. The EC had indicated that they needed to just collate just about 5 or 7 polling stations. But because of other reasons, we were pushed into...
But the same EC came out to say that a certain number of polling stations should be rerun.
Because EC consistently, even before Parliament, had indicated that they had all the results, left with about 7 or so. And they were denied security to complete that process.
No, they could not. They were given security, but people from wherever came to disrupt the process.
No, the EC came to Parliament time and again requesting that the IGP provided security for them to complete just about the 6 or 7 collation. Then all of a sudden, because of political machinations.
But we don't know that, do we?
Oh, I'm telling you because of where I sit. Because nothing convinces me why we have to go and do rerun of those polling stations.
Maybe because the parties couldn't agree on those numbers or on those polling sheets or pink sheets.
So EC's hand was bent, and then this is where we are. We took it in good faith. We lost it. Akwitia, we had the seat. We went into a by-election, properly so-called. We lost it. But for this matter of Pandai, I believe that if the Court of Appeal sits on it, we are going to win our case on appeal. And there will be no need for a by-election. Should the West come to a by-election, I'm sure we are going to contest that seat with Matthew Nyendam. I'm very optimistic that we will win that seat in Banda. Should we even lose the Banda seat, I believe that the government will be held accountable by the mighty minority. We are going to do our best to protect the Ghanaian citizens and their interest in Parliament. As we speak now, a lot of matters come before us in Parliament. If we had real numbers, they wouldn't go through. But now the majority are always having their way because they think they have the numbers. Everything we do under certificate of agency. Everything certificate of agency. And then you go and pass the laws, and then you later realize that there are a lot of issues around them. So, Pandai, I believe that we have expressed our position. We are against the decision of the court, but we are going to contest it. I want the court to just make the determination on our stay of execution so that at least Matthew Nyendam will continue to serve the good people. Because if they don't, then it means even as the case is on appeal, are we going to do a by-election? And then what happens is the same thing we discussed about the Chief Justice removal and how do you enforce your rights even after another right has been. So let's see how it goes. But I think that we should get to the state of execution.
But the state of execution, you must demonstrate exceptional circumstance.
Oh, but we have we've
before,
indicated 44 contest. Someone is contesting 41 polling stations, and now you throw all under the water and say we should go and conduct. So what comes?
And you first have to convince the same judge before you go up to repeat the application.
Yes, but the judge, I think, out of only courtesy and fairness in law, one has a right of appeal, and he has triggered that appeal. So what will you do if I come to you and say, stay your execution as I go on appeal? What kind of convincing again do I have to give to you as a judge to convince you that you should allow a stay of your judgment, execution of your judgment, as I have that right on appeal? And we are saying that the grounds of the appeal basically sit around why you will nullify, someone claims to nullify 41 polling stations, and then you go ahead and say that we should go and rerun against 117 or so polling stations. It's inconsistent with decisions from Akufo-Addo versus John Mahama 1 2023 petition, and even the Ablekuma one that we had to rerun only specific polling stations. If the person has contested issues around some polling stations, and you want to be fair, let's go back and do rerun of those polling stations. Why do you want us to go and conduct a full rerun of the Ablekuma? So that would be my thought. I think there are so many good reasons why the appeal should be sustained on behalf of Matthew.
Andrew, what's your thoughts around that? I mean, the minority appears to be. Things keep coming up. Should on Monday, Tuesday, can the speaker go ahead and declare it vacant, or the stay of execution holds his hands?
Yeah, so I think the speaker, like he acted in the previous, is a very lawful speaker. Yeah, you understand. On is it Tuesday? On Tuesday, he's going to declare the seat vacant because he said that the only reason why he's staying in execution is because of the law. The law, generally when judgments come,
the 7 days.
There's a 7 days, and that's the only reason why he's not declared the seat vacant. So
even though there's a stay of execution, the execution is the declaration of the seat not vacant, not part of the execution.
No, because unlike an injunction, a notice of a stay of execution.
No, it operates as a stay.
It does not.
No, it does. A notice, no.
Unlike an injunction.
Even the injunction, that's
so for injunction, not of.
Yeah, so the stay, the stay operates as a stay.
No,
the stay of execution.
No, it does not.
No, it does.
It does not. You become.
No, that is correct. But it does. If not, then things would have happened. So it is the filing of the notice of appeal that does not operate as a stay, but the filing of a notice of filing of a stay of execution operates.
Maybe you need to give me an authority for that because what I know is that a notice of an injunction is as good as an injunction.
Yes,
I don't.
That of execution is even more serious than the injunction. When the injunction is debated, depending on where.
So after you just give me after just give me authority. Now. But for me, the biggest story for me is the reaction of the minority leader. I would have preferred that he had taken my brother's position. Because when Nanado had the presidential, go against him in 2013, you understand? His famous press conference. Because of his position as a former Attorney General and as a presidential candidate, he acted in a manner that did not undermine our constitutional democracy. You understand? Any elements of the arms of government. Now, in the way the minority leader went about his press conference, to the extent that he called
the kangaroo court.
In fact, he said what's called animal farm. Essentially to say that the judiciary or the judge is biased. I feel that it undermines what's called our judiciary in the way, as in he can disagree like you did. You said you don't agree with the judgment, you're entitled to say that, and that because of the avenues our constitution itself has given, because our constitution has given us an appellate avenue. It's giving you a supervisory avenue where, let's say, under the right second, you can even go to court and quash by way of a statutory. You understand? So then our constitution has given you avenues to challenge decisions of the court. So why don't you fall on those avenues without necessarily, because of the position you hold, make statements that undermines the integrity of our judiciary. And unfortunately for me, I think that's the biggest story. The way our politicians are quick to undermine this constitutional democracy, that has benefited all of us.
But the challenge is that it comes from both sides.
That's why I said, and that's why I use the word politicians.
You see, and that's why I use the word. Were so much on the judiciary, criticizing them, condemning them, using unprintable words on them. And we should move away from that.
That's why I said I use the word political. I think on this show once I criticized the chairman of the NDC for saying that Jane Mensah should be removed. Because then what happens is that immediately, I know somebody has petition, but it's very easy for somebody to then say that, listen, is the NDC, which is witch hunting, hey, because we need to keep the integrity of the system intact, and the politicians have a higher responsibility on that, especially when you are a leader of parliament. You should not be given what's called a narrative that suggests that our judiciary is biased. You don't agree with the decision. I've heard I haven't read the judgment myself. I've heard what you're saying, and it's a very cogent argument you are making, and I think that's what gives you the confidence that you succeed should you go on appeal. So yeah, I think that should be our attitude, and then let's see. But for me, I know that you are a mighty minority, but my position has always been that it shouldn't just be the duty of the minority to oppose or to not oppose, to serve as a check on the executive. It's the duty of the entire parliament to serve as a check on. But they don't. Exactly. So unfortunately, because of that, we the citizens are exposed. Yes, and if because the same party that sponsored your president also sponsored the majority, and then because of that, they don't allow everything to go through. Then the purpose for which we separated the powers of state will be and I think we should look at it.
Now let's look at this Afenyo-Markin ECOWAS court matter. What do you know about the situation? Afenyo-Markin was a member of the ECOWAS Parliament. Yeah. It had to be reconstituted. His name was taken out, but he found his way there. I don't know on what ticket he went, whether he went on his own and paid his own ticket, or Parliament paid for him. Normally, on such official trips, Parliament will bear the cost. In this case, I'm not sure Parliament bore the cost because the majority leader would have known. He found himself there, and understand it became an embarrassing situation because he insisted to be part of it when indeed the official list submitted and read out by speaker did not have his name. Let's have the speaker, let's hear the speaker citing Afenyo-Markin for contempt and referring him to the Committee of Privileges for further investigation. And the action follows a petition from the majority leader, Mama Yarega, after the minority leader opposed moves to exclude him from Ghana's ECOWAS delegation.
Honorable members, having reviewed the complaint, the standing orders, and the governing principles, I am satisfied that the matter raised prima facie implicates the dignity and institutional integrity of this House. Pursuant to Order 1041, I therefore refer the matter, the complaint lodged by the Honourable Member for Boko Central and a majority leader to the Committee on Privileges and Immunities for examination, inquiry, investigation, and report to the House.
That's Speaker Babin. Honorable Nyako, what do you know about the situation? What do you know about the facts of the case?
Okay. So let me just put on notice that the Banda case has now been taken over by our Director Legal, Senior Gary Nimaku.
Okay.
And I'm informed that on Tuesday he's even going to appeal the decision or challenge the decision at the Supreme Court. Those processes will be filed by Tuesday.
Okay.
So that is the information I want to put on record. Okay. But on this ECOWAS Parliament and matters arising, it's an unfortunate incident, but we brought it upon ourselves as Parliament. Because you see, at the 9th Parliament, which is what we have, committees are constituted. Every Parliament, when it takes effect, constitutes its committees, whether select or standing committees. And then one of the committees, or some of the committees that we constitute, include representation to Pan-African Parliament and ECOWAS Parliament. And in so doing, we have specific numbers that we send, delegation that we send. And we need to send those delegations based on our representation in Parliament. That is majority, minority. Now, Ghana delayed our submission of those names because we failed to disagree on even the sharing proportion of these representations in Parliament. So from January, February, March, when we constituted the various committees, that of ECOWAS Parliament, Pan-African Parliament, and the rest, were on hold. Many times, many occasions, we displayed them on our order paper, and yet we never took a decision. Because if we had like 5 or 6 representation, the majority would want to take 4 out of the 6. And we debated this over and over. So finally, we agreed on that representation. I think 4-2. And then on that representation, it is the caucus that has to make the nomination for people to represent. It is not Parliament Sobotu, the speaker, who decides that I want A, B, or C to represent the minority. So majority submits their names, minority submits our names. Now, we've had practices or conventions where in sending representation, your position in Parliament may entitle you to one. So, for example, in ECOWAS Parliament, normally the deputy leaders are part of the representation. So, in the case of Afenyo-Markin, in the 8th Parliament, he was a deputy leader. Then,
In the ECOWAS Parliament.
In Ghana, before he became the leader, majority leader. So his representation to be part of the Ghana delegation
was automatic.
Was so because he was the deputy majority leader. But ECOWAS Parliament also has a term. And that term doesn't run with our term. And so, though we moved on to the 9th Parliament, the ECOWAS Parliament session has not ended. And so Ghana reconstituted our numbers. But then because Afenyo-Markin was already in the ECOWAS Parliament and was the 3rd speaker, deputy speaker for that parliament, we, the minority, decided and agreed that he should continue to serve on the ECOWAS Parliament. And then our deputy leader would take other positions or other representations for us. Mahama Ayariga from the majority side, and for whatever reason, were insisting that the minority leader should be replaced by the deputy leader because that's the convention. And we are saying that we want the majority leader to be on there. So one of the days when our minority leader was absent for health reasons, that issue, which had always been on our table, was raised. And then they did an amendment to change for the deputy leader, which is Patricia Appiagyei, to be on. And then Parliament passed that resolution. So by their numbers, the resolution was passed to replace Afenyo-Markin with Madam Patricia Appiagyei. Then Madam Patricia Appiagyei immediately petitioned the speaker. Now, no, that has not been our position. So she declines that offer to be on that list. Officially communicated to speaker that she rejects that nomination. That is not the position of the caucus. And so Afenyo-Markin remains one of our representation to the ECOWAS Parliament. Now we are being told that it is not our choice or my party's choice to say that I will not go. Because Parliament has made that resolution, you are compelled to go. But because she has declined and has indicated so, there was no way she was going to make a representation in the ECOWAS Parliament. So when finally they went to ECOWAS Parliament, Afenyo-Markin appeared. And rightly so.
Appeared as what? Because the list...
Forget about the list. I'm
saying... The list is... When the speaker speaks, it's law, right? The list, as the speaker read out. And indeed, that matter came to the knowledge of the speaker. And the speaker emphasized the need for a woman and the deputy.
Why didn't the majority people bring all their women? Why? The woman representation. So if you want more women, why? They have more women there. Why do they necessarily have to rely on us to bring female representation? We have only 2 reps or 3 reps. And we have decided that these are our representatives.
How about a deputy leader convention?
No, and I'm saying that is the convention, but that rests with us. If Afenyo-Markin had gone to continue his term, you never know the caucus discussion to bring my party on board at a later time or what have you. That is our decision. And I don't want a parliament that wants to use procedure, processes, circumvent matters, create a monster, and later come and say that Afenyo-Markin is bad and he has disregarded and has brought the name of Parliament into disrepute. All the letters that my party wrote and rejected, why do you compulsorily want to put a name in the list?
No, but so why didn't the matter come back to the floor of Parliament that Mama Pat, Speaker, yes, you read out the list, Mama Pat has rejected it or has declined. So what is the way forward?
But they knew.
No, but is that not how it's supposed to be?
No, the point is that because
for those of us watching, we knew that Mama Pat was to be there. Of course, we saw her refusal of it.
Yes.
But we're waiting to hear the next step. That, okay, we nominated this person, he or she's declined. It doesn't mean that the old order remains.
No, but
there should be a new
I agree with you. But that's where I'm coming from, that same day or the next day, if the minority deputy leader writes to you as to Speaker, Mahama Yaga is in the known, that there is no way, because you are trying to bring a rift between even our leadership. It's our representation. It is not your representation. It is the minority's portion. And we are decided who we want to represent. And you are on notice. So why did you continue to push this issue of Maapat to ECOWAS Parliament when you could have just by notice avoided all of this embarrassment? And for good reason, the person that is our leader is a 3rd deputy speaker. The term has not ended. He has given all the indication, and in our house, we don't have much. But at least we've tried to share everything for everybody in terms of committee representation. So we don't have any difficulty at all at our caucus level. You have made your representation. We have made our representation. And you want to compel us because by convention, and we debated this on the floor. Muntaka gave all the historical antecedents and so on and so on. Why? Is it not just ECOWAS representation? So if we choose to move our parts from one area to another place and we agree amongst ourselves and so on and so forth, why do you then send the list to ECOWAS? You know that we have declined. My part will not go. She cannot go. Afenyo goes, and then now you are creating that he knew his name was not there, and he has come there and has created some embarrassment, and so he should be referred to privileges committee. Please. Yes. We shouldn't do this to ourselves.
I'm wondering how he went there. How, because normally Parliament would have sent you there, would have paid for you to go there. And everything.
But he paid on his own.
But is that a practice?
Which
you
practice?
Don't pay on your own. Parliament
but
pays
later,
for you.
when you rectify it, you come for refund. No, you see, no, maybe on more. No, you see, we have the spirit and we have the letter. We want to be respected as a caucus and as a minority. You see, you can't ambush us, use your numbers and resolutions to compel us to do things that we have agreed as a caucus not to.
No, but you see, this is interesting because the same Afenyo-Markin in 2017 was at the center of this. In that case, he became the good boy. When Fredo Pareansa also went in a similar manner. And he said Fredo Pareansa said he was the guy. He also went like that. It took Afenyo-Markin as a young MP then to relinquish his seat and said no, he should take it. He will not be part of it.
Exactly.
Before the ECOWAS Parliament swore in Ghana's delegation. So he, having been in the center of that before, should have known better, which means that he actually knew what he was going there to do. He knew exactly what the situation was going to be, and he intended it to be so.
And so you see, I don't want to go to the mess, the end. But my point is that we created it ourselves here. It was avoidable
you
here.
failed to correct it here. So, for example, I don't know your processes, but somebody could have filed a motion or a question seeking clarity on this, given that my part had rejected or declined the nomination or offer. So that will compel Parliament or Speaker to make a pronouncement.
No, but what I'm saying is that Speaker was seized with that notification. He never responded.
The mischief. So he never responded.
He never responded to my part.
Yes.
That I've rejected.
Yeah, but it's not the first time. There's a way people bring his attention to things to compel him to make a determination on a matter. That wasn't done. And Afenyo-Markin himself, who is a master of that, never did anything. Another prayer who does that so well, also never raised any issue. D-Day comes and you fly on your own to the place, pay your own bills, pay your own hotel bills, and you drive yourself to the place.
He's a member of the parliament. He's already a member of that parliament.
But he's a member of that parliament because he's a member of Ghana's parliament.
His term has not expired.
But he's
the ECOWAS Parliament.
What's the practice? If he had lost the seat, would he have still been a member?
He had lost his seat.
He would still have been a member of that parliament.
No,
but go and check the ECOWAS, the parliamentary protocol. I did that check.
So that if you are having 6 representations, you have that 6 will include a non-MP in
No,
Ghana.
they will give them notice that we'll lose going forward. But now he's still a member of parliament.
Anyway, so let me take your views.
No, but I'm surprised you are surprised in the sense that what Afenyo-Markin is doing and the letter part, and thanks for your, because thanks to you, I now appreciate
the matter.
The matter. You see, because of their parochial nature, they think public positions are their personal properties. You understand? Because how on earth can you, the minority leader, former majority leader, try and behave in a manner contrary to the resolution of Parliament? Because Parliament acts by resolutions. You understand?
This was foisted on them.
It wasn't foisted. No, majority is like we vote in Ghana. Yes, I wanted.
It's our slot. Who comes.
But subject. But no, it will certainly be subject to the approval of.
Yeah, but you said you have 2 or 3.
For example, so let's say it's
you have 5 or 6.
So they say we have 6. Bring somebody, but that somebody will be subject to our approval, and that's the resolution.
So they are amended.
No, it's a resolution. It's Parliament resolution. Yeah, because it's the resolution of Parliament that will tell. Yes, and so they say, oh, listen, we have 6 space slots. We are very charitable, even though we are mighty, and you are very. We will give you 2, but the 2 that you are going to bring, that person will have to get approval of Parliament by way of the resolution. Because when they go to the ECOWAS, they are going to use the resolution. Yes, so it does not mean that if you bring anybody at all, we are going to. Now, they wrote a convention. Parliament itself wrote a convention. The convention says that whoever is deputy leader has a slot. Yes, and
Afenyo benefited from that.
That, exactly. And right now, you are majority, and Parliament is saying that no. You understand? So, you cannot disrespect the ruling of Parliament. You cannot. Essentially what you are saying is that you don't respect Parliament. That's what Afenyo did. And I'm saying, for me, I'm not surprised because he thinks it's his property. And you are asking all the right questions. So you take your private money, you understand, to undertake a public service. But it's still service. You understand? And you go there, so you take your money.
Attempted service.
It's a service. Come on. You understand? So, and I'm saying that I'm not surprised. Because it's the character of this current MPP. When I say it doesn't mean that every MPP person has that character. It's not that everybody, but generally. And it's showing that because how can you, the deputy Parliament has taken a decision, and you are writing a letter to tell you what you want because you swore to serve us. And when you go to the ECOWAS Parliament, you are representing the people of Ghana. You are not representing yourself. You understand? And then because you know, and she ought to know, I'm talking about my part. So it's not just Afenyo-Markin who, in my view, has heard, but in my part. You understand? Because you ought to know before, when you even became an MP, that when you became deputy leader of the minority, as part of your responsibilities.
This is what is that convention.
You understand? So that when a resolution has been made and they insist on the convention, you do not write as if it's a personal issue. It's not a personal issue. You are not representing yourself. You are going to represent us. And per the convention laid down in Parliament, she ought to know that immediately you become deputy minority leader, you have a seat
at the
ECOWAS Parliament. So why should this bring a conflict between you and your minority? Why is it that, so far as Afenyo is concerned, he has a permanent, and it shouldn't matter whether he is the deputy speaker or not. Even if he were the speaker of the ECOWAS Parliament, per the convention and per the resolution of the Parliament of Ghana, where they said clearly that, listen, step aside, you ought to respect the position of the Parliament of Ghana. Also, what kind of message is he sending to with the ordinary citizens of Ghana, that where a law or a policy does not favor us, then we have a right to disobey that? No. Yeah. And for me, it's a worry. We are seeing too many of this parochial familiar spirits in how they are handling public office. You're a minority leader and a judge. You've taken an oath to be faithful to Ghana. You took an oath. Anna, you took an oath to be faithful to Ghana. I want to be faithful to Ghana. And where an arm of government has made the decision, you go and then you term them as animal farm. It's not saying that they are biased. That is being unfaithful to Ghana, being unfaithful to the ideals of Ghana. So I'm not surprised, but the MPP needs to reassess themselves and change for the betterment of all of us. You understand? For the betterment of all of us. You see, when you are an MP, now I wish you had taken the position my brother here. He's put my brother here ready for. I understand you. If you go and say what I'm saying right now, you have trouble.
No. But you see,
yes, but it's not your private property. It's not private property.
But what I'm saying is that this issue dragged for a long time. And for us as a minority, okay, give us our due.
Yeah, I understand you, but they've given you your due. They've given you two. The due is two.
To bring our names.
But Parliament has a right to reject. It's like dry vetting. Parliament has a right not to approve somebody the president brings. The fact that the law says that president brings somebody does not mean that Parliament is obligated to pass
the president.
Everybody the president brings. It's the same thing. Parliament is saying that, you know something, my minority workers bring two people. It does not mean that whoever you bring, they are going to pass.
Yes, if you not pass.
But the other side is that it does appear that the majority is pressing their neck or pressing Afenyo-Markin's neck.
But that's the system. So you can use the system to press your neck. You understand? The point is that there is a parliamentary resolution. There's the parliamentary resolution. See, this is not the first time the MPP has had a serious minority. The MPP became a force based on the performance of that 1996 minority.
Yes.
But the performance of that minority is what made the MPP for a very long time, in my opinion, become the party of choice in this country. They did so well. But I think this kind of minority, and there's a lot of people in this minority who are fantastic. As in Patrick Boama, excellent guy.
Himself.
Yourself, I've met you a number of times. Excellent guy. You understand? I think my problem, and I'll say it here without any fear, I think the leader, the majority leader, is leading you into the abyss. You are free to say no. But let me say it without any. Listen. I'm saying that sometimes when I talk about MPP, it pains me because it's not everybody in the party. I'll be unfair if I ascribe my view generally to every. I'm mentioning names here. I take someone like Patrick Boama, excellent, yourself, and I can mention even Emma Pat. That's why I'm surprised she wrote what's called that letter, which in my view is very parochial. There are a lot of fantastic people in the minority, but I think the way the leader is leading you guys. Is leading you into the abyss because, unfortunately, the small goodwill the party has is reducing further because of the kind of leadership he's given. If Parliament, for which you are a leader, has made a resolution, you do not go to and flout the resolution of Parliament. It's not just Parliament he is disrespecting. He's disrespecting the entire people of Ghana because the Parliament is a representation of the people of this country. So if Parliament has made a decision and you think you disagree with the decision, there's a way to go about it. But you don't take the law into your own hands because you have money, fund yourself, go to a hotel and appear when you're not supposed to be there. It's wrong. So I get your point, but there's a better way, a better way to have what's called protested, not by the minority leader funding his own travel, funding his own, and then going and appear. So I support the position the Speaker has taken. I pray that it does not lead to his expulsion from Parliament. Maybe they can reprimand him and I hope parliamentary, the minority, and all parliamentarians for that matter, learn that you cannot flout a resolution of parliament. If you disagree, I think there's a way to challenge that.
Does the minority feel, of course, the numbers, the difference in the numbers, very huge. Does the minority feel, of course, you guys say you don't feel intimidated, but in real sense, do you feel emasculated, if you don't use the word intimidated or cowed, by these workings of the majority using their numbers? Because if the numbers were almost similar, I'm not sure this would have a reason.
Yeah, so we can't deny the fact that based on their supermajority, they have various ways through which they can use to cow us or subdue us or make business or life in Parliament very difficult. That has never been the practice. But in very, very high stakes level, that is when you see the effect of the majority numbers against the minority. But on many occasions, we've built consensus to do the things of Parliament. What I am pleading with the Speaker and with Mahama Yariga as our leader of government business and the entire Parliament is that, you see, let's respect each other and build consensus.
Mm-hmm. You think this is about Afenyo-Markin, or is just about, because you think the majority wants to find a way of silencing him?
No, that was all it was about. Okay, if it wasn't because of it being Afenyo-Markin and the way he pushes,
because he appears to be doing quite a lot with the ECOWAS Parliament, bringing the whole Parliament to a futu for their sessions and things like that.
So if not for the way he's doing his things and the majority thinks he's been a hard person
in their flesh.
In their flesh. So then we need to also use other mechanisms to break you down. So that one, but it's part of politics. It's part of the business in the house. So we have to make sure that we avoid things that would also put us within those spaces and circles, and that will bring about. I think for us as a parliament, nobody would want to disregard resolutions of parliament or even the directives of the Speaker of Parliament. But all of them are avoidable. When we know clearly that this thing wouldn't help as a house, and that is where I want the majority leader to at times stand up, Mahama Yariga. He foresaw this happening. He foresaw it.
So it was a trap they set, and Afenyo fell into the trap.
Of course, but why do you set the trap?
But it's a game you guys play. It's a game you guys play. Now, I want to do with the content matter. The privileges committee matter. But a few messages. Somebody who was applauding you for your views on the Wesley Girls matter is saying that no, he doesn't agree with your view on this minority decision at all. It's SK Dread. He said, as a minority caucus make decisions for Ghana's parliament, isn't the Speaker the final authority on pronouncements on decisions? If the House has made a decision on an issue about the position of our nation, how does a caucus in the House defy that? Afenyo needs to be reprimanded for him to know he is not above the law. He's been getting away with this for far too long. Please ask Isaac if when going to ECOWAS Parliament, one pays for their own flight and hotels. If the answer is no, then Afenyo-Markin knew what he was doing was not right. He should be punished, period. These are views. So you are in Parliament. The Committee of Privileges appears like a very fearful place to be. But in the past Parliament, when Adisadel and co had those issues and were to appear there, we saw that the disagreements in the committee actually impeded the committee's ability to progress. Maybe that was helpful to the people who were called before the House, the committee. But in this case, it could be dangerous because the NDC has overwhelming majority even at the committee level. And so it does appear that they could make very far-reaching recommendations to Speaker, which could include expelling Afenyo-Markin from the House. What does the caucus think?
Yeah, so every committee of Parliament operates based on the powers imposed on it by the standing orders. And the Privileges Committee is one of the major committees that we revere. because that is the only committee that has powers to review conduct of members of parliament and make far-reaching recommendations that can lead to even your expulsion from parliament. So it means that apart from judicial decisions like the Banda or other matters that can get you out of parliament, the only other way someone may lose their seat in parliament is under your appearance to the privileges committee. And we want to keep respecting committees of parliament. And I know that once he's been referred to the committee, he will appear before the committee and the committee will hear him, give him fair hearing. If the committee comes up with any final decisions, it will just be a report to plenary for us to discuss it. And normally per our standing orders and the constitution, to even remove someone from parliament, you need not less than 2/3. And these numbers already set with the majority. So it can be a very frightening and threatening thing. But as I always say, we build...
But you think the majority can go that length?
Oh, they won't do that.
They won't do that.
They won't do that.
As a way of saying this, so they don't do it.
Oh, they won't do that. They won't do that. I think it's just a signal for all of us to note that Parliament is an institution governed by rules. And we should all respect the rules of Parliament. Even if we disagree, we should have our ways of expressing our disagreements rather than being seen to flout. And Speaker is very particular when it comes to respect for the institution of Parliament. And we all want to side with him. Because if we don't respect Parliament, then who will? If we don't respect Parliament, who will? But I'm saying that the Privileges Committee is a respected committee. The majority leader and all of us, we are supporting him in this as a caucus because, as I said, this was a caucus position. And so if they were minded, they should have even threw it back to us to re-look at it, but not to ambush us by amending that list for us. Because I'm sure if we had done...
Was it an ambush or you guys knew about it?
No. That day, I said that resolution has been in our books for months. I have personally risen on Friday business to ask when our committees will be set up, when this ECOWAS Parliament. I was the last person that moved for the ECOWAS Parliament representation to be concluded. Okay? But the day it was passed and how it was done, it wasn't done with finesse. Because, as I said, nobody chose the majority's list for them. They took them, and all of the representations, we brought them up. So you didn't vary the Pan-African Parliament. You didn't vary the IPU. You want to vary the ECOWAS because you don't want the minority leader to go for other reasons.
The minority that would be somewhere else. He could be in the Pan-African Parliament or...
No, so that's what I'm saying. That so if the majority even doesn't want the minority leader to be there, you engage us again and get us to... Because you could have gotten our caucus to know, and then we would have a way of engaging our leadership to see if we can do something about it.
But from your explanation, you said that per your convention, whoever was deputy minority leader...
Go to ECOWAS. The other one goes to Pan-African.
So the majority was just following the lay-down convention.
And Afenyo wanted to use maybe his interest in the ECOWAS to distort that process. So it means that instead of him going to maybe Pan-African Parliament or is it IP or LP, Part would then have to go. You would have distorted the convention because of what?
Meanwhile, because of we are doing rule of law, you know that certainty of practices is always the best. So we all ought to know that where you are deputy minority leader, you know that you go to ECOWAS. You don't want a situation where arbitrariness and the whims and caprices of people will determine some of these things. And I think I was going against this fundamental principle. You understand? And that's why I'm saying that. He's just reflecting the character of the party now. Because so you will recall last year, your party itself told us, and indeed it is in your constitution, that if you contest against a candidate the MPP is sponsoring, automatically you are not part of their party. You applied it in 2020, Andrew Isiama, my own friend Andrew Isiama. Then last year, when certain people left your party, as in contest against candidates that you are sponsored, because of the spirit of arbitrariness, the MPP suddenly said that no, even though they are contesting against people we are sponsoring, they have not left our party. You understand? That brings uncertainty, and we don't want that. So, and I think it's a spirit that's driving Afenyo. Well, we all know that if you are deputy minority leader, in future, let's say in future you become deputy minority leader, and I hope that you will become deputy minority or majority very soon. I like the way you handle your sense. But you know immediately that once I'm this,
well, once you are confirmed as you know that this is what
is happening. And so the majority was not pressing your neck. They were just insisting on sticking to their lay down conventions. And we should applaud them for that. So the minority shouldn't take it personal. It's not personal. We would have had issues if they wanted to change the lay down convention. But they did not attempt to change the lay down conventions. They were just advising people. Stick to the convention. That's all. Stick to the convention.
What form would the reprimand take? Or he would just be reprimanded before Parliament, or suspended? I mean, what form can he take, and what can he do to redeem himself? Does he go there to argue his case, or he can go there and apologize for embarrassing Parliament in the manner he did, and then matters will be made to
so it all depends on the appearance before the Privileges Committee, the explanations.
And his good friend, I have for chairs the committee.
Yes, and the explanations that are given. I believe, as I said, he didn't do that with a sense that he wanted to disobey parliamentary resolution. But it was because maybe we have clearly articulated our position that we wanted him to continue. So yes, he had the support of the minority, but unfortunately that was against the resolution that had been passed by Parliament. And I thought we could find a way of still resolving it than to go to ECOWAS and be faced with that kind of unfortunate incidents that occurred. So in terms of the outcome of the Privileges Committee, it's all about...
From where you sit and from the minority position, you think he will fight this legally, as in he will be legalistic about it, go state his case, or he will just go and apologize and pray that matters will...
I'm sure as a caucus, we may even have a conversation around it. And as our leader, we continue to engage in. Let's leave it at this stage and look at all the issues around them. And then I'm sure once we appear...
Chris Akume, who is a senior lawyer, is saying that given that this is ECOWAS and maybe the same thing would have been reported in other countries, Afenyo-Markin must be pardoned if he apologizes in the leading newspapers of the countries forming the ECOWAS.
But this matter is not before the people of ECOWAS, it's just the Parliament. So if you want to apologize, you can go to...
Reporters would have reported it.
We've not cited any international report. You can check from...
No, but the ECOWAS Parliament represents all of us.
Yeah, but fortunately for us, it is not published in any of the ECOWAS newspapers.
He should go apologize, Guinea newspaper front headline, Guinea-Bissau, everywhere. Then
everywhere. Sorry for this. I mean... That interesting. I mean, the Privileges Committee. So, what's the membership of? You are the membership of head. You are a member of the Finance Committee. Yes. And where else? What else?
Environment Committee and then House Committee.
So when the decision is made at the Privileges Committee, no matter the kind of decision made, the House will still have to pronounce on that decision.
That is so.
So the House could overturn the decision of the Privileges Committee.
Yes, the House can. The House can.
I see. So if he is suspended, it will be for a certain number of days.
Yes.
But he can be sacked, though. I think we should say that. No, so.
Yes, it can be. They can make recommendations for him to be expelled.
Expelled from Parliament.
I'm getting some information from former MP for Kankwe North, Fuseni Issa. There's always a confusion about Fuseni Issa. It says when NDC removed Muntaka and Haruna as leaders, they were made to continue in the regional parliaments. This was against the convention, but was ratified by the caucus.
Yeah.
I see. I didn't have that information. So if that has been done before, then we will have to relook at this Afenyo matter again. Maybe that confusion was not there. Maybe the difference between this one and that one, if indeed it happened, was that now there was confusion even in the Ghana Parliament before one took the step of going to ECOWAS on its own to go and represent the country.
And also that time was 137, 137.
137.
And no resolution had been passed to change them.
Exactly.
So it was all by consensus.
Consensus.
Okay.
And that was a clear
Right.
resolution.
So
Yeah, this one
it
was a clear
is a resolution
That changed the matter.
that
All right. So, okay. So, this is the big issue. Thankful that you joined us today. This is how we conclude today's edition of the program. My guests this morning, in the first part have been, of course, Professor Kojo Apije, Professor of Law, University of Ghana School of Law, Apostle Emmanuel Okule, GPCC General Secretary, and Rapia Dankwa, Head of Legal, United Party, and Isaac Boamanyako, Member of Parliament for the Ifia constituency on the ticket of the NPP. And of course, they did justice to the second matter as well, where the minority leaders referred to the Privileges Committee, and we also looked at the Pandai matter and a few other things. Thanks so much for doing the viewing and the listening. My name is Selom Adunu. Thanks so much. Catch you same time next week. Have a good afternoon.